In 1985, when the Delaware Supreme Court refused to invalidate Household's flip-over poison pill, it was a stunning victory for the designer of the pill, Marty Lipton. But it was also the beginning of a long process of testing when and how long the pill could be used. As the Supreme Court warned, while we conclude for present purposes that the household directors are protected by the business judgment rule, that does not end the matter. The ultimate response to an actual takeover bid must be judged by the directors' actions at that time, and nothing we say here relieves them of their basic fundamental duties to the corporation and its stockholders. Their use of the plan will be evaluated when and if the issue arises. In other words, a board can adopt a rights plan or poison pill. But when do its fiduciary duties require it to remove that obstacle to an unsolicited takeover bid? How long and for what purpose can it be maintained? To stop a front-end loaded two-tier tender offer? To prevent a bidder from shutting down an orderly sale process? To protect a restructuring plan favored by the board? To protect stockholders from having to decide whether to tender where material information is missing? To protect stockholders from an inadequate offer? In other words, can a board just say no? The first two questions got answered quickly. After the Unocal case in 1985, no one could doubt that a board of directors could use a poison pill to fend off a structurally coercive two-tier bid like Mesa's bid for Unocal. And in short order, in 1988, a series of opinions from Delaware's Court of Chancery established that a poison pill could properly be used to protect an ongoing sale process from being circumvented by consummation of one bidder's tender offer. But in a case seriously exploring the so-called just-say-no use of the poison pill would take over 20 more years to arrive. We'll come back to that case, the 2011 opinion in Air Products versus Airgas, in a bit. But 1988 brought some important developments affecting the use of the poison pill, including the controversial opinion by Chancellor William Allen in the Interco case in November of that year. Those who advocated a robust role for the poison pill had to be pleased when the Court of Chancery, earlier in 1988, ruled that, under Delaware law, a board has both the duty and responsibility to oppose inadequate offers. This court, therefore, should not order the redemption of rights where the effect of the redemption would negatively impact the shareholders' ability to realize full value for their shares. This is so, even if the tender offer is for all cash. But just 2 months later, the Interco case exposed a serious limitation on the use of a poison pill. Paul Rowe, of the Wachtell-Lipton firm, which represented the company in that case, put it pithily.
If Household was the birth of the pill, in the Interco case, it had a serious heart attack.
Mr. Rowe's partner, Michael Schwartz, explained the backdrop of the case.
The Interco board was one of the boards which had adopted the pill in the interim between the Chancery Court decision and the Supreme Court decision in Household. So the Rails has made a tender offer, or announced a tender offer, and management determined that the offer was financially inadequate, and therefore, as the pill permitted, determined not to redeem the pill to facilitate the offer. And the Rails has brought suit trying to force us to redeem the pill by injunction. There came to be a sort of takeover defense called just say no, where a board would fail to redeem the pill and basically do nothing else. But more commonly, a board faced with a tender offer would fail to redeem the pill, but would also engage in a competing financial transaction of some sort. And so the Interco board did. It announced that it would do a recapitalization, it would sell off certain assets, and borrow some money, and that would finance a rather complicated transaction, the net of which the board believed was financially more valuable to the stockholders of Interco than the Rails' offer.
True, the board believed that their alternative transaction was more valuable than the Rails offer, but not by much. As little as $76 per share versus $74 per share. The company's lawyers, however, stressed one difference.
The Rails' on a couple of occasions, increased their offer price. I think it started at 70, 72, 74, but at the end of at the point at which it came into litigation, the Interco board believed, based on the financial advice it had received, that the recapitalization was worth more than the Rails brothers, and in first of all, just dollar terms, but that critically depended upon the fact that the recapitalization involved the Interco shareholders continuing to have an equity interest in the business on an ongoing basis. So, from the perspective of the Interco board, the upside, so to speak, implicit in the future prospects of the company would belong to the shareholders and not to the Rails brothers.
But that difference wasn't enough to carry the day for the company and its board.
And we litigated the issue before Chancellor Allen. And this is the dramatic moment, Chancellor Allen agreed with them. He decided that the pill had to be redeemed. That, in his phrase, the end stage of the takeover process had been reached, that while reasonable men could differ about exactly what our recap transaction was worth, nobody claimed it was worth 100 times what the offer was. The margin between the two was relatively modest, and that at that point the Interco board was under an obligation to let the shareholders decide between our recapitalization and the Rails' tender offer. And so he announced that he was going to enter an injunction compelling the Interco board to redeem the pill. Those were dark days.
Chancellor Allen, of course, defended his ruling.
Interco was not a just say no case. It was not a case where the board said, we're not talking to you, we're not doing anything, just go away. They did a recap transaction. They said, okay, shareholders, you want to get the premium. We don't think that's really a deal for us, for you, but we will reorganize things and give you like a big bunch of cash now as a special dividend, okay? A little meat to the lion. Once you do that, this is what I thought, still think, you have come up with an alternative transaction. The takeover says, I want to give you a lot of cash now, or I want to give you stock in cash. And the board says, no, we want to stay in control, redo things, and give you smaller cash, stub share, some other stuff. So you have two transactions. It's not just say no. In my mind, the pill was a perfectly legitimate device to give the board time to negotiate a better deal, or to give them time to make another alternative that the shareholders may think is better. It shouldn't be a thing that says, no, we're going to stop that and give you this. So that was my thinking. So that meant that if you have enough time to get an alternative together, and if this other deal is not structurally coercive, then that is exactly the moment when you would say, okay, now is the time to pull the pill.
After several years of uninterrupted victories for the poison pill, this ruling was a real disappointment to the pill's advocates.
Because just to set the scene again for our audience, it had been 3 years since Household.
Yes.
And the reason why this came as a shock or unpleasant surprise was that in that period, no chancellor or vice chancellor or judge elsewhere had ordered redemption of a pill.
Correct.
Despite the fact that, as you said, that 400 or 1,000 companies had adopted pills, and there had been an enormous amount of takeover activity in that 3 years. So what made this dramatic wasn't only the result, but that it was the first time, at least in Delaware, when a judge had said, I have found that case that
Right.
that the household Supreme Court imagined might come one day, when in fact a board's unical duties requires the redemption of the pill.
Yes. I mean, there may, I'm just recollecting, there may have been some other judge somewhere else who had reached that decision already, but not in Delaware. And I have to say, Chancellor Allen, who later became our partner here at Wachtell Lipton, was a preeminent jurist. I mean, I think everybody would agree he was one of the great chancellors of the Court of Chancery, and so it wasn't just any old Delaware judge. This was Bill Allen, a first-rate judge, saying, in his judgment, the end stage had been reached, and the board could no longer fail to redeem the pill. So it was a very dramatic moment indeed.
What particularly disturbed the advocates of the poison pill was the idea that the pill had a limited life expectancy and had to be removed once time to explore and develop alternatives had elapsed.
We argued, when we filed our brief, we argued that the effect of that was essentially to neuter the pill, because as you put it, a bidder could simply say, well, I'm going to make my offer, I'll wait till the end stage, and then I'll walk off with the company. I mean, we did not think, with all due respect to Chancellor Allen, we had to argue, and we did argue, that it really didn't make any sense. That the judgment of the board, assuming, again, the prerequisites of the business judgment rule are satisfied, that the board is not motivated by entrenchment, that it's acting on an informed basis, that it has competent advisors, et cetera, all those prerequisites having been met, that the board's judgment has to be sustained.
But that argument, of course, didn't prevail at the time, and it failed again just 2 weeks after Interco was decided, in a case decided by then-retired Delaware Supreme Court Justice William Duffy, challenging Pillsbury's use of its poison pill against an all-shares, all-cash tender offer by Grand Metropolitan. In that case, in which Pillsbury also launched a restructuring plan in response to the bid, Justice Duffy said, I agree with the Chancellor's analysis in Interco, much of which I have followed. And here, too, the respective positions are sufficiently developed to permit an informed shareholder choice. This was surely the low point of the poison pill in Delaware. It even spurred Marty Lipton to publish a controversial client memo recommending that corporations migrate out of Delaware to a more hospitable state.
Right after Interco, you wrote a memo saying, well, it's time to think about migrating out of Delaware, maybe going to Pennsylvania, New Jersey, or Ohio. After Pillsbury, I'm not sure you could control the words on the page. What was your reaction? Were those idle threats? Were you appealing to a broader audience, or were you really saying, no, this issue is enough to make people go somewhere else?
Well, it was clear nobody was going anyplace. First of all, you couldn't get the vote to leave Delaware. It was basically designed to try to get legislation that, look, the courts are not sustaining this, and something that would be effective in giving time on a hostile takeover, or would permit a liquidation or other transaction that the directors felt was appropriate under the circumstances. And that, look, all these other states have adopted legislation. It's time for Delaware to adopt.
But Delaware didn't adopt such a statute. And even in the Interco case itself, things soon took a different turn.
And there ensued several oral arguments, which were among the most challenging of my career, in which my job was to say, okay, we accept your decision, but you should not enter an injunction against us pending appeal. And moreover, you should enter an injunction against them doing anything pending appeal.
Because otherwise they could have closed their
Yeah, they're going to close their offer.
And the appeal would have been nugatory.
Exactly. So my adversary there was also a Skadden lawyer, a guy named Bob Zimmett, good guy. And at the end of the day, I prevailed. I persuaded Chancellor Allen that not only should we not be enjoined, that is to say, affirmatively compelled, but he should be enjoined. And Zimmett couldn't believe it. He said, I won the case. Turns out you're not enjoined, and I am. But that's what happened. It was like pulling a very big rabbit out of a very small hat, okay? Anyway, the judge did, therefore, prevent the Railses from closing on their offer while we went to the Supreme Court of Delaware.
And while the case was on appeal, the Rails brothers dropped their unsolicited tender, mooting the case.
I thought it would be appealed, and the Delaware Supreme Court would have their say. I mean, I had no desire to have my hand writing all the rules. I just did my part. An appeal was taken, but the plaintiffs were being financed in some way, and something happened to their finance. I heard rumors later. Anyway, they dropped the whole thing. So Delaware Supreme Court didn't get a chance to work their magic on that case, and it stood for a while.
So the ruling in Interco escaped direct review by the Delaware Supreme Court. But that court didn't wait much more than a year to pounce on that ruling in dictum in the 1989 case of Paramount versus Time. Here's what they said. Paramount's position represents a fundamental misconception of our standard of review under Unical, principally because it would involve the court in substituting its judgment as to what is a better deal for that of a corporation's board of directors. To the extent that the Court of Chancery has recently done so in certain of its opinions, we hereby reject such approach, as not in keeping with a proper Unical analysis. CEG Interco and its progeny. A lot of people took this as an outright rejection of the logic and outcome in Interco. Certainly that's how Chancellor Allen understood it.
If you look at my opinion in Time Warner, almost the first sentence in the opinion was, nobody's relying on a poison pill here. It's not an issue in this case. I had a suspicion that the Delaware Supreme Court might not like Interco. And then on the appeal of Time Warner, even though the poison pill was not relied upon, the Supreme Court went out of its way to say, in some of its recent cases, the Court of Chancery had fallen into error because it has taken upon itself to make the choice of what the company should do by forcing the pill to be redeemed, in which I thought was really an unfair characterization of what was going on, because what was going on was the court said, no, now in Interco, now it's the moment for the shareholders to choose. The court didn't dictate the result.
Others, like Larry Hammermesh, who represented Time and its directors, and Justice Randy Holland, who helped decide the case, didn't read the Time Warner dictum as a clear rejection of Interco.
The way I remember people reading that dictum after the Supreme Court opinion came out was, oh, Interco and Pillsbury got overruled. But if you read the words carefully, it didn't say that. It was to the extent that those opinions require the court, permit the Court of Chancery to engage in, essentially, I'm paraphrasing, but second guessing or substituting its own judgment about the business merits of a bid, that we reject that. So I'm curious, Justice Solomon, if you can say anything about it, but whether I'm being too hard on people who think that that was a matter of overruling those cases.
Yeah, I don't think that was the court's intention. And as you can gather from what I've said, every paragraph in that opinion was really thought about carefully crafted. There was a lot of back and forth between the three of us. And to the extent those two cases were a subject, the first question is, what, if anything, do we need to say about them? And then when we say it, what do we say? And I think to the extent the court decided to make a comment, the plain language, I think, indicates it was making a comment without making a decision. And so that was really what the court was trying to do, was to make a comment. I'm not saying the interco paragraph was not my idea, but, we thought carefully about the way we wrote it.
And with that carefully drafted but equivocal shot across the bow, Delaware case law on the poison pill went largely silent for about 20 years. The reason for this wasn't a mystery. Once feared as a death knell for hostile takeovers, the typical pill had lost its poison, if it ever had any to begin with. In one case in the year 2000, the Court of Chancery even described a poison pill as garden variety, and observed that a bidder could overcome it simply by electing a new board. All an acquirer needs is the necessary votes to elect a new board, which can redeem the pill and allow the offer to go forward. In short, even if a board wanted to use the poison pill to just say no to an unsolicited bid, the bidder didn't have to take no for an answer for very long, with one exception, where the board is staggered, divided into 3 classes, with members elected to 3-year terms. It takes 2 annual meetings to replace the board. And if a board can say no for 2 years, the poison pill still has a real kick. So the critical question about the poison pill became this: is a board's use of a pill for 2 years, in the face of a structurally non-coercive all-cash, all-shares offer, reasonable in relation to any threat posed by that offer? In 2010, then Vice Chancellor Leo Strine hinted in the Ukaipa case that the answer to this question was no. There is a plausible argument that a rights plan could be considered preclusive and therefore unreasonable based on an examination of real-world market considerations. When a bidder who makes an all-shares, structurally non-coercive offer has 1. Won a proxy contest for 1/3 of the seats of a classified board, 2. Is not able to proceed with its tender offer for another year because the incumbent board majority will not redeem the rights as to the offer, and 3. Is required to take all the various economic risks that would come with maintaining the bid for another year. But the Vice Chancellor thought such acts of resistance when a bidder has won 1 proxy contest appear to be rare. Rare, yes, but that's exactly the situation, less than a year later, that gave the just say no poison pill defense its most searching exploration in the Airgas case. The story of that remarkable case emerges from interviews with several of the key players. Ken Nakbar of Morris Nichols Arston Tunnel of Wilmington, who represented the bidder Air Products. Kevin Shannon of Potter, Anderson & Caroon, also in Wilmington, who represented the target, Airgas. Ted Mervis of Wachtell, Lipton, Rosen & Katz in New York, who also represented Airgas. And last but not least, former Chancellor William Chandler, who presided over the case in the Court of Chancery. As we'll hear from these participants, nothing in this case was terribly predictable, and it was far from clear that this case would end up testing one of those rare acts of resistance by a target board.
Early on, did you anticipate the significance or the potential significance of the case, because this was one where you had a poison pill that had been deployed, plus you had a classified board, and there had been a fair amount of commentary among the academics and practitioners about really the duration with which you could maintain the pill in that circumstance, particularly if there had been one proxy contest where the potential acquirer prevailed the first time around, which happened here.
I didn't expect that it would necessarily be a case that would set law in that regard, because if you think about the cases where it was addressed, they never really answered the question in full, because quite often it never got that far. Something happened, and in fact the opinion notes that no one ever stayed long enough for 2 meetings or anything like that. So the fact is that it's not that unusual to have a pill that's in place for a period of time, but for the court ultimately to have to make that final decision, quite often it gets resolved before that. So it certainly teed up the issue, which was subject to a lot of commentary. Did I think the court would, at the end of the day, have to resolve that, where the court had not in many other cases? No, but as it went along, it was pretty clear that both sides were pretty adamant on their positions. Airgas of the view that it was worth much more than Air Products was offering. Air Products, although suggesting it would go higher, I think made clear it was not going to go into the range that Airgas was requiring.
When the complaint was filed in February of 2010, did you anticipate the significance or the potential significance of the legal issues that were involved?
Well, you know, we've all had in our careers a lot of poison pill cases, right? I mean, lots of people have poison pills and have for a long time. Obviously, if you're doing a hostile offer, one of the things you have to do is you have to challenge the pill. So it wasn't any more significant than any other case. It became more significant because this one actually went the distance. A lot of them, you know, the bidder goes away if they get rebuffed, or more likely they cut a deal and they don't really ultimately get litigated. So, you know, we knew that it had the potential to be an important case, obviously, but so did the last 20 cases challenging pills, you know, all of which got settled or went away. So what made it unique was really the staying power, you know, of Air Products, who pursued this for, you know, I think over a year when all was said and done.
And Air Products had plenty of motivation to pursue a bid for Airgas.
The business combination made a lot of sense. I mean, I don't think anybody could doubt that. They were sort of complementary lines of business for sure. And so, you know, there would be synergies and an opportunity for, let me back up. Airgas was an amalgam of small companies, you know, mom and pops that were very successfully rolled up into, you know, a company, but it served, you know, auto shops and small businesses and provide industrial gases. Air Products, on the other hand, served corporate America for the most part. You know, they would have, you know, gas facility at an Exxon plant, and Air Products would actually build a plant at Exxon's plant and, you know, provide very high volume industrial gases, you know, and so they're doing tanker trucks or you know, sort of bespoke plants, whereas Airgas is mostly doing canisters. But you know, obviously the two businesses are complementary, and there is some overlap in the middle. That was the idea.
In the early stages of the battle, things definitely broke in favor of Air Products' bid, especially in terms of support from Airgas stockholders.
Even at the time of the stockholder meeting, a lot of the stock had moved into the hands of arbitrageurs. So they were, for the most part, you would assume that they were looking for a deal to happen, because if Air Products went away, it was likely that the Airgas stock price was probably going to fall, at least somewhat, for some period of time. That turned out to be a double-edged sword for your side, but did that factor into your analysis going forward?
Well, we certainly knew that stockholders,
yes, the arbitrageurs were going to support us, and as more ARBs moved into the stock, our level of support was going to be high because they wanted a deal.
And when Air Products put up a competing slate of directors for election at the September 2010 Airgas annual meeting, the stockholders not only elected the Air Products nominees, John Clancy, Robert Lumpkins, and Ted Miller, but also voted out Airgas's CEO, John McCausland, at least temporarily.
Let's fast forward to the annual meeting and the proxy vote. Your side had a good result. You had 3 new directors.
Well, we thought we had a good result.
At least.
We were very happy at the time.
On September 15th, at the date of the annual meeting, you folks must have been ecstatic. All three of your nominees were elected. Mr. McCausland was, defeated, but then he was put back on the board. But he was no longer going to be able to serve as chairman.
Then Air Products had a daring idea. Why wait a whole more year to elect a second set of nominees? Why not have a meeting sooner, just a few months later, and get a majority on the Airgas board to eliminate the poison pill? So at the same meeting where the stockholders elected its nominees, Air Products successfully proposed a bylaw change advancing the next annual meeting to January 2011.
The January meeting, we had great debates about whether that could be moved up to, October of the prior year or November. And, I said, look, you can't have the 2012 meeting in 2011. I mean, come on, you can't, there's limits. So that's how January got picked. It was, there were a lot of people who were counseling that we should do it in, December of the prior year or November of the prior year. I never thought that was going to work, but, we thought we had a shot with January. But more importantly, you think the other side's going to maybe cave and maybe try to cut a deal at that point, right? They just got pretty soundly defeated at the polls. The stockholders, certainly expressed their viewpoint. We put in place a bylaw that said that, we can have the next meeting in January. It's just a couple of months away. At that point, we're going to control the board. I give McCausland and the Wachtell team a lot of credit because a lot of people would have folded up shop at that point. Sort of the handwriting kind of is on the wall, and we were, I think, obviously at that point, our probability of winning was probably pretty high at that point to anybody objectively looking at it.
Air Products' chances of success looked even higher when Chancellor Chandler rejected Airgas's claim that the January meeting bylaw amendment conflicted with the staggered board provision in Airgas's Certificate of Incorporation, providing that the directors' terms of office expire at the annual meeting of stockholders held in the third year after their election.
The Chancellor didn't see it your way, and he pointed out in his opinion that because he found the charter provision to be ambiguous, he had to construe it in favor of the shareholder franchise, which in his view meant that the stockholders should be permitted to elect directors at the next, in light of the bylaw, which would have been in January.
In the Court of Chancery, there was a footnote in the briefing by Air Products that referenced the notion that if a charter is ambiguous, it should be construed, and I think the words are something very close to this, it should be construed in favor of the stockholder franchise. Now that sounds like plain, apple pie. And the notion of that is very powerful. If a charter is ambiguous, and you don't know how to interpret it, you should interpret it in favor of the stockholder franchise, because after all, the charter is deemed to be a contract between, in somewhat of a legal fiction between the corporation and the stockholders for the benefit of the stockholders.
Whenever words are ambiguous in a charter or in a bylaw, if they're ambiguous and they touch upon the stockholder's right to vote or the stockholder franchise, we have a rule that says a judge should construe that ambiguity in the way most favorable to the stockholder franchise. And I invoke that policy to say, there's this ambiguity. If I invoke that policy, then I come out in favor of saying this is a different way of expressing it. And the election that's held in January of 2011 falls in the third year of the 2008 directors, and so it qualifies under the language and isn't inconsistent with Airgas's charter. And that policy, just for those who are interested, that policy is a long-standing policy, and it's based on a very fundamental proposition. And that fundamental proposition is that the shareholder franchise is the ideological underpinning of the very legitimacy of directorial power, on which the legitimacy of directorial power is in fact rests or is based. And so it was with that principle that I invoked that led me to my conclusion.
If this view had continued to prevail, the decision on the poison pill might never have happened.
The court could have said, look, why should I have a trial and make a decision on whether the board is required as fiduciary duty to redeem the pill when the bidder will have had an opportunity to elect 2/3 of the board in a very short period of time. Indeed, notice that the only thing that sort of undergirds my speculation is the fact that there was no decision in the pill case, which was fully tried, while the bylaw case was on appeal.
But this is where fortune turned in favor of the Airgas board. The Delaware Supreme Court reversed, finding that the Air Products attempt to convene the next annual meeting in January impermissibly shortens the directors' 3-year terms, as provided by Article 5, Section 1 of the Airgas Charter. The Air Products bid had setbacks in the market, too.
An unusual and interesting part of this case is that you had facts developing real time while you're going through the litigation, as opposed to sometimes deal litigation where there's a deal announced and then there's kind of a post-mortem as to whether or not the board fulfilled its fiduciary duties. Here you had real live proxy contest, hostile offer, facts changing on the ground. How did that play out, and did that present challenges?
No, the biggest fact on the ground was, as you pointed out, we were coming out of a recession. The air gas price, stock price, had been depressed, and it kept running up. And there were several times when it rose above our offer, and not just necessarily because the market anticipates a bump. They were starting to show better results over time, and so the stock price kept going up as the market kept going up. And I think probably Airgas outperformed the market. They're kind of in a cyclical business, so they had a cyclical recovery. So we were chasing the stock price a lot as this saga unfolded, and that's why the offers kept increasing. But they were never really a blowout, 40% premium or something like that. So that was that challenge.
Related to the point about chasing the stock price, it became clear during the trial that Air Products wasn't making its best bid, a fact that substantially undercut its claims that the Airgas board was obligated to remove the poison pill as an obstacle to its tender offer.
One of the facts that came out at the trial, which seemed to influence the chancellor, was that Mr. McGlade and I believe one other person had testified that $65.50, which was the offer price that was on the table at the time, was not the final offer, that there was potentially more there. How do you deal with that issue after the evidentiary record's in and then you're getting ready to go and brief post-trial? Because the chancellor obviously was concerned that there's a possibility of getting more for the stockholders. The board said $65.50 was inadequate. How is the judge going to step in and essentially, if he's going to enjoin the pill, you're likely to get a deal at $65.50 with enough people to tender so that Air Products takes over the company?
Yeah, no, I mean, obviously that was a bad fact, but, you know, people, I mean, I guess they've got to testify honestly, and, you know, that wasn't the best and final price. So it's a tough situation. I mean, I guess, you know, I don't know, maybe you could argue that's an improper question to ask, but, you know, if you object to it, you're kind of implying that there's more there. So you're kind of stuck either way, I think.
You also had an additional problem in that regard because of a document that had been produced inadvertently earlier in discovery.
Yes, thankfully not by my firm, but I was sitting in a deposition and I got a call at the deposition, and I can't remember what the offer was at the time, but, you know, basically a document had been produced that stated our reserve price, which was significantly higher than the current offer. Obviously not a helpful fact. And it was interesting how that played out, though, because, you know, the other side tried to use that document and basically, I think, maybe move for judgment on the pleadings based on it, or summary judgment or something. They tried to make some very aggressive motion. And, you know, the chancellor sort of smacked them, and, as I recall, and said that, you know, look, that was obviously an inadvertently produced document. You had an obligation to return it, not to try to use it to win the case at a threshold stage. So I think that one, you know, it might have boomeranged a little bit in the short run, but, you know, the chancellor can't unknow what he knows. So, you know, knowing that our reserve price is more than our offer is obviously a problem. I think we ultimately bid the reserve price before all got said and done in the case.
It was apparent in some of the motion practice or motions to compel, and your side pressed very hard to show that the various offers that had been put on the table by Air Products were not their final offer, and that they were always willing to go higher. What was strategic behind your trying to bring that out?
To us, that was an extremely important issue, because the question before the court wasn't one in the abstract or generally when should you pull the pill. The question was whether the Airgas board was breaching its duty by not pulling the pill in response to the offer that was currently in front of the board. People can debate how long you can keep a pill in place, but I think generally it's viewed that one of the benefits, especially given the distinction between a tender offer and a merger, is that the pill can be used as leverage to get the best and final offer. So if we could show, which I think largely until we got to $70 was undisputed, that what was on the table was not the best and final offer, then it would be very hard for the court to conclude that the board was breaching its duties by keeping it in place. In fact, the board was complying with its duties to get the best and final offer.
The pill case was litigated in the middle of a flux, because the price was raised after the trial. Indeed, the very first day of the trial, the CEO of Air Products testified that whatever the bid was at the time, thinking it was 63, or was not necessarily the highest price Air Products was willing to pay. Now, when I heard that in the courtroom that day, I thought the chancellor was going to stand up and say, well, then why are we here? Why are you asking me to order the directors to redeem the pill in favor of a bid that you not only say, you argue is not the most you're willing to pay? Why would I ever do that? Or why would a board ever be expected to do that? To pave the way for a bid that's not the highest price that even this bidder is willing to pay?
Still, it was more than plausible that the Court of Chancery could echo the ruling in Interco and the suggestion in Ukaipa, and conclude that even if the Airgas board was right in concluding that the Air Products offer was inadequate, the pill was a preclusive and therefore invalid defense, and the choice of whether to tender into a structurally non-coercive offer should be left to the stockholders. That's how Air Products counsel saw things at the end of the trial.
At the close of trial in the fall. How did you feel coming out of that trial with respect to your prospects of prevailing?
We felt great. I mean, like I said before, you know, under existing law, we had to prove that the offer was not a threat, and that the pill was not reasonable in response if it was a threat, and particularly we would prevail if it was coercive or preclusive. I think we proved all three of those things, and I think the opinion reflects that.
And yet, facts matter. And one development that occurred after the trial dramatically changed the atmosphere in favor of the Airgas board.
In the intervening period between the close of the testimony at trial and the Supreme Court's decision on the bylaw, the company, the three new directors, or the board unanimously had rejected 6550, and that included the three Air Products nominees. That could not have been helpful to your case.
No, that was always a terrible fact. And, you know, I mean, look, and again, I give the other side tremendous credit for, you know, just doing a great job with those directors. And, you know, we always talk about independent directors, and there's always a question, you know, are the independent directors really independent? And, you know, there's a wink and a nod, I guess, sometimes, or cynics say, yeah, they're not really independent. Well, we put on people who were independent. That's, you know, we understood that. We did think that they would think that the company should be sold, but the other side, you know, did a great job, and with the lawyers and the bankers, of explaining their vision for the future.
I would certainly say that that made a huge difference. I mean, we felt that the record from October was very good as far as the Airgas board's grounds for believing the offer was inadequate. They had put a 5-year plan in place that suggested strong growth going forward. They were starting to achieve those results, but having someone who Air Products put on the board who endorsed that view after, in his explanation, he really kicked the tires, tested management. He believed that the plan was extremely thorough. They were in the process of implementing SAP there, which could have a huge impact on a company like Airgas, which really grew by virtue of a lot of different acquisitions. So having someone who was appointed as an Air Products nominee come in and endorse the view of the Airgas board that it was inadequate, and having all of the Air Products nominees endorse that view, but you know, Mr. Clancy probably the most vocal, and not only endorsing the view, but exercising and stating that keeping the pill in place was very important. We also had the fact that one of Air Products' own directors said, when faced with a similar situation, he would have done the same thing. And that all of that, I think, was part of the record in the subsequent hearing, which I think was a very compelling factual record. It is, by any measure, an uphill battle to try and keep a pill in place once the best and final offer, a premium offer, is on the table. In this case, we were able to put that record together.
That record, which was developed in a supplemental evidentiary hearing in January of 2011, after Air Products raised its offer to its final bid of $70 per share, was critical to Chancellor Chandler's ruling declining to require the Airgas board to eliminate the poison pill.
I was getting the facts written and the story told, and by the middle of November, before the Supreme Court's decision, I was leaning in favor of Air Products, of ruling in favor of Air Products and requiring the board of Airgas to redeem the pill and allow the tender offer and allow the shareholders to choose. That's where I was kind of tilting towards that. That changed dramatically after the evidentiary hearing in January, where I heard from the three directors two of the three directors who've been put on the board by Air Products, and heard their testimony and heard the testimony of their financial advisor from Credit Suisse. That completely put me in the camp of coming out the way I did and writing the opinion the way I did.
Were you surprised that the three new directors felt so strongly about the value of the company? Because that seems to really have been the turning point for you.
I guess I was surprised in a way. I mean, I was impressed with how much conviction they had. I mean, they'd been on this board since September, when they got elected on September the 15th. But they really jumped into it head first. They got Credit Suisse involved. And I was impressed with how much learning they had done to get up to speed. I was impressed, too, with how much the other Airgas directors had really brought them into the fold, hadn't treated them, at arm's length and kept them at bay, but really had brought them in and helped educate them about this company. It's really excellent 5-year plan that it had and how it was executing on that plan and reaching every milestone that it was expecting to reach ahead of time, actually. That was all very impressive to me. So yeah, I was happily surprised in a way at how persuasive those directors were.
So, one could second-guess Air Products' strategy of putting forth director nominees committed to making an independent evaluation of the Air Products bid. But that second-guessing is unlikely to be persuasive.
Have you ever given any thought as to what the result might have been had, for example, the Air Products nominees or Air Products said, we are putting in people who are going to vote to redeem the pill because this is a fair price, as opposed to what actually happened, which was nominees who Air Products proclaimed would be independent and that would exercise their fiduciary duty as to whether or not this was a fair price?
I don't know how it would have been different. I think ultimately the Airgas board's decision would ultimately have been sustained. It was a question or a tactic that a lot of people second-guessed over time because, as we talked before, the importance of the Air Products nominees supporting the Airgas board's position was, I think, critical in the case. Obviously, if they had put a number of people who had already committed to sell, that would not have happened. It was an interesting strategy, but not in hindsight that surprising, because if you look at the vote, I think the view was that they would have had a difficult time getting their directors elected if they were basically on the slate that we will pull the pill and facilitate the offer. And whether people truly believed that their nominees would be independent, certainly they had more support for putting independent people on than people who had committed to pull the pill. So although someone might criticize after the fact making that decision and how it turned out with the nominees coming on the Airgas side, I think if they had instead picked people who were partisan to Air Products and committed to pulling the pill, I think there's a very good question as to whether those people ever would have got elected in the first place.
Their platform, they ran 3 independent directors, and it was on the basis of these folks will go in and make an independent judgment. They'll take a fresh look and advise you shareholders what you should do. So you should listen to them because we're appointing independent people. They could have taken a different tack. I mean, Air Products could have said, we're sending in 3 nominees, and their job is to redeem the pill and convince all the other directors to redeem the pill. But they didn't do that. They took, probably for a strategic reason, because if they had tried to do that, they probably wouldn't have gotten the shareholders to vote in favor of it. That's what a lot of the institutional investors said later, is that they wouldn't have voted for a slate like that. So that was strategic, but it had an ironic effect. And I'm sure Air Products wasn't pleased that their 3 directors came out the way they came out, but that's the game they played.
One could also second-guess Air Products' incremental bidding strategy and wonder how things would have turned out if they had come out with their final $70 per share offer right from the beginning.
Do you have a view as to what might have transpired had Air Products initially came up with a higher offer? Your side clearly made an issue of the fact that this was not their best and final, that there was much more that they were willing to offer. You ever thought about if they had gone to $70, say in the spring, in advance of the proxy contest, how that would have affected the dynamic?
I can't say how it would have impacted the ultimate litigation. Certainly, their appeal to the Airgas stockholders is more compelling if the number's higher. So I think if they had gone out earlier with it, it would have further supported electing their slate. Certainly would have put more pressure on the Airgas board, but one true practical aspect of it is, as the Chancellor pointed out, by raising their price gradually over time when they thought it was necessary to stay in the game, whether to elect directors or move forward, they allowed Airgas period of time to show improved earnings, which is what Airgas did, which further supported the argument that the price is inadequate. So in that regard, doing it over time, I think, helped us. Certainly helped us establish the reasonableness of the board's conclusion that it was inadequate. Hopefully, convince some stockholders that it was inadequate. Although, as a financial strategy, it makes ultimate sense to pay the least amount you can, try and figure out what that is. As a legal strategy, do I think they might have had a better chance if they came out right at the box at their highest? Sure. Do I think it would have changed the result? Not necessarily, but it would have made it a more difficult argument along the way for Airgas.
But Air Products didn't do that, and Chancellor Chandler ended up sustaining the Airgas poison pill, although not without reservations.
In reading the opinion, particularly your recitation of the facts, which you said that you had started to write in the fall, early winter, it appears that you were really struggling with how you were going to come out on this case. You had a hard time believing that an inadequate price alone represents a threat. It was clear that Airgas had been given more time than any other litigated poison pill case in the history of the Delaware Court of Chancery. There had been 16 months since the offer was made public. There appeared to be, you said there appeared to be no threat here, that the stockholders have all of the information that they need to know to make a decision on whether or not to accept the offer or not. Yet you went on to say that you were compelled by precedent to accept that inadequate price alone can be a valid threat to corporate policy and effectiveness. What is it in the case law that drove you to that view?
Well, I don't want to take everyone on a long doctrinal excursion, but I think there were decisions from our Supreme Court that, and I'd been reversed in one of them, Unitron, where I think they made it fairly clear that they accepted the proposition that an inadequate price could constitute substantive coercion and that stockholders could mistakenly tender into an offer, not listen to their board of directors and not pay attention to what their board was advising them, not be as informed as those directors, and make a decision that was an erroneous decision because of that. So to me, that's where the doctrine led me, was that was the inescapable conclusion that could constitute an actionable basis for saying there was substantive coercion. So that's how I came out. I'm following what I thought. I'm a trial judge. I'm not an appellate judge. I don't get to make the law. I don't get to create law. I have to follow it and apply it to the best of my ability. That's what I was thinking I was doing there.
And you ultimately found that the board had satisfied its obligations under Unical Unitron.
I did.
If Chancellor Chandler was skeptical about the idea of substantive coercion, he wasn't alone. His predecessor, Chancellor Allen, who decided Interco, had the same misgivings.
So this is kind of amusing. Well, amusing in the way that anything in the subject can be amusing. I have been friends with Ron Gilson for 30 years. And my co-author for my book is Rainier Crackman. And Crackman and Gilson are friends. So they sent me this when I was doing Interco or Time Warner, I forget which. They sent me a draft copy of an article they were writing. And I looked it over. I didn't spend much time on it. Ron Gilson writes beautifully. Everything he writes well. And Rainier is a very, very sound thinker. So at some point in one of those opinions, and maybe you can tell me which one, I cited their article. And the reason I cited it is not because it actually, I cited it more than once, maybe twice. I cited it because they were nice guys and they sent me the article. They were my friends. It was smart. I didn't disagree with it. And they had in there this concept of substantive coercion. Now, Gilson and Crackman, to locate them on the intellectual
spectrum.
Thank you, Paul. They're not Bebchuk. They're not so shareholder-oriented as Bebchuk, but they're like all academics. They think shareholder choice is a good idea, and so they're trying to analyze these. And they say, well, if the pill should stay in place if you have coercion. But then they come up with this idea, this phrase, I can't say an idea, I'll just say a phrase, of substantive coercion. Coercion can be actual, structural, or it can be substantive. What is substantive coercion? Well, according to the Supreme Court of Delaware, anyway, I'm not remember what Ron and Rainier said. Substantive coercion is that shareholders, when given the choice, may make the wrong choice. They may not follow the board's recommendation. In what sense that is coercion, I will never understand. And how people as bright as Rainier and Ron could use that word coercion in that context, I don't understand. It was a great mistake because they were not, from a policy point of view, they were not in favor of keeping poison pills in place forever or indefinitely. But they said that there could be a substantive coercion. Well, the Supreme Court grabbed hold of that idea and said that the Court of Chancery, in some recent, said in Time Warner appeal, the Court of Chancery has fallen into the mistake of exercising its own judgment. But in fact, it shouldn't, because the pill here is protecting against a risk of substantive coercion. That is, that shareholders may not be smart enough to follow the advice of the company. Well, I think that falls of its own weight.
Chancellor Chandler's imminent retirement from the bench may have at least partly explained the skepticism he expressed in his opinion about the state of the law he felt obliged to follow.
This case was, by my calculation, the next to last trial that you held in the Court of Chancery before you retired in June of 2011. Was that weighing on your mind as you wrote your opinion?
That I was going to be retiring from the court? Eventually it did. I mean, by December of 2010, January of 2011, I knew I wasn't going to be on the court a whole lot longer. I didn't know a precise date, but it was pretty clear to me that I was nearing the end of my tenure. So it influenced me some in terms of, for me, I don't want to speak for all trial judges, but trial judges are careful about venting their spleen and opinions that are going to go up on appeal, and I was fully confident this one was going to go up on appeal. It didn't, but I thought it would. So you have to be a little careful, a little judicious about that. But when you're a short-termer, it frees you up. You have a certain freedom, a certain liberating feeling that you get from knowing that you're out the door and you can say some things that maybe you wouldn't say otherwise. Well, respectfully, of course. But
there's a footnote 480 in your opinion that I'd like you to read aloud for us and tell us.
480 footnotes. You want me to read this?
Sure.
Okay. Our law would be more credible if the Supreme Court acknowledged that its later rulings have modified Moran and have allowed a board acting in good faith and with a reasonable basis for believing that a tender offer is inadequate to remit the bidder to the election process as its only recourse. The tender offer is in fact precluded, and the only bypass of the pill is electing a new board. If that is the law, it would be best to be honest and abandon the pretense that preclusive action is per se unreasonable.
Not something that you would have written earlier in your career?
Probably not quite that way. But as I said, I have no problem with the decision. I think the decision is correct, and it wouldn't matter to me how it came out in the Supreme Court. But I do think it's helpful if the Supreme Court knows that sometimes the doctrine needs a little trimming, a little pruning, a little clarifying to be less than. Sometimes you can get disingenuous in the way the law develops, and that's not healthy or wholesome in my view.
But the Delaware Supreme Court never got the chance to consider Chancellor Chandler's invitation to reconsider its poison pill doctrine.
Ted, one more question on the pill case. Were you surprised that Air Products did not take an appeal?
Yes, very surprised. For the simple reason that having spent, 14, 15 months pursuing Airgas? Okay, so they lost in Chancery on the pill case. It's not like they had nothing to say. Why not throw in another brief, it would have been expedited, spend another 2, 3, 4 weeks litigating and see what the Delaware Supreme Court thought. It was also what's surprising was the speed by which they withdrew. I don't think a human being could have finished reading the Chancellor's opinion before they withdrew.
In fact, once they saw that their client had lost, the Air Products lawyers didn't even need to read the opinion before moving to drop the case, as Ken Nakbar explained.
Once the opinion came out, what was the thinking on an appeal? I mean, the company, decided not to appeal and just pulled their offer. Did you have any view, or were you disappointed? Did you want to take the case up?
Yeah, I was disappointed. I wanted to take the case up, but we, as I said, there was some tension within the company as to whether to go to 70, whether to either stick at 65 or just pull the offer altogether at that point. The compromise, and I knew this before the hearing, was we'll go to 70, we're not going any further, we're not doing an appeal. If we win, we get the company at 70. If we lose, we're moving on. We've been doing this for a long time. It's, sucking the energy out of the company, and we're just gonna get on with our business. So I knew before the argument that there would be no appeal. Now, I say that was certainly what the client had communicated. In the back of my mind, depends what it says, right? And you never say never, because, if you had a juicy enough issue where you could say we have a 95% chance of prevailing, I think we certainly would have made the argument, and we would have maybe lobbied for an appeal. But look, I think the client felt that they had lost at the Supreme Court after what they thought was a well-reasoned, favorable opinion. They weren't feeling the love at the Supreme Court. And I think the client's view, like I said, was we've put enough time, effort, and energy into this. We're either going to get the company or we're going to move on.
And in a story that has made Airgas a poster child for supporting the poison pill, it turned out to be a good thing for Airgas's stockholders that Air Products decided to drop its $70 per share offer and move on.
You did receive some criticism in academia for the opinion, but ultimately I'm going to give you the last word on whether you feel you were vindicated.
Well, how can I not be able to feel vindicated? Because all during this trial, too, you should know that there was rumors that there was another bidder, and that's why the stock price was kept getting higher than the bid from Air Products, because there was rumors among the ARBs and the hedge funds that there was another gas company interested, and they were in the wings waiting to swoop in. So what ultimately happened, though, is Airgas was sold. Its price, as a stock price, went up to $100 within 6 or 8 months after this trial. Its stock price was $100 a share. It was eventually sold to Air Liquide for $143 a share. So I feel happy for those stockholders who hung on, and not for those ARBs and hedge funds who sold out right away.
So, did the Airgas decision really enable boards of directors to just say never to an unsolicited bid? The experts say that's reading too much into the decision.
I think the answer is that a board of directors can just say no. But it isn't just saying no. They have to withstand scrutiny under an enhanced standard of review, which means a judge is going to look at exactly how well informed that board was. Did they have an adequate informed basis to make their judgment? And then did they respond in a way that was reasonable? So it's not easy to just say no. A board can just say no, but it has to be able to meet that exacting standard to do it. So that's the point. Yes, you can say no, but it's not just saying no. You have a lot of work to do and a lot of arduous journey to go through to be able to get to the end of the road with that just say no.
Now, you went out of your way also in your conclusion to say that this case does not endorse just say never. Some folks didn't see it that way.
Well, that's sort of a soundbite kind of thing for people to say that. I mean, the reality is, if in this case, Air Products had made an offer of $70 back in February of 2010, we probably wouldn't be sitting here having this conversation. You know, they waited until the December of 2010. As I said, Airgas had gotten to be a stronger company. All of these things had happened. If they had come with a higher offer earlier, wouldn't be here probably. But my point is, you know, if enough money is put on the table, you know, even a board that's convinced that there's a great company with a great future, there's a point at which it cannot resist. It just cannot. Once the price gets high enough, it will have to give. That's just the market, the way the market works and the way the pressures of the market work. It doesn't have anything to do with the law. That's just human nature. That's going to work that way. So there's never going to be you can just say never, and you'll never have to cave to a price. You will eventually, if it's high enough.
Well, I think you can say never, but you've got to have the record to support it. So if you're going to say never, it helps to have 3 independent directors who say that, you know, your best and final offer isn't good enough. You know, if we had responded to the decision by saying, okay, how about if we offer $85? I guess it wouldn't be never. I mean, I assume at that point, you know, Clancy, D'Annunzio, and the other guy would say, yeah, no, like, now you have to sell.
And even though the Airgas opinion validates the most aggressive use of the poison pill ever tested in court, the inventor of that device doesn't think it has much impact anymore.
Accomplish something. It has a basic no real import today. I mean, when 3 shareholders have between 12 and 20% of just about every major company, you're dealing in a different world. And so the 3 indexers have central control over all of the major companies that have single-class securities. And so the poison pill doesn't really mean anything. There isn't a board today that I'm aware of that isn't totally responsive to what the top 10 shareholders want. So I'm not aware of any company. You know, every now and then you get one, but no company stands up to the top 10 shareholders saying that's a deal we want you to do.
Indeed, the statistics demonstrate that the 1985 decision in the household case was hardly the end of mergers and acquisitions. Still, the poison pill and the Delaware cases confronting it have been a major force in the M&A field. Art Fleischer of the Fried Frank firm in New York provides a fitting epitaph.
I would say it's the single most important development in the takeover field and serve the basic functions that it was designed to, one, increasing the negotiating power of a target board, preventing the taking of control in the marketplace. I mean, when you think about it, it is truly an extraordinary invention that still has vitality and will continue to have vitality.